now we have come to the last panel. We have arrived at the last panel discussion of today, and we still have a surprisingly large audience. So I would like to congratulate ourselves because it clearly indicates the quality of our event. And I agree with you, the presentations have been very interesting. We are practicing lawyers. So in this last session, we will discuss the matters that we are dealing with concerning children's rights or the rights of children living with vulnerabilities. I asked my colleagues to obviously present specific cases and what they thought were very interesting in these cases. For example, characteristics that they thought were very challenging from a legal perspective. I also asked them to cover what experiences they have had with their clients, especially if they needed some kind of a special solution due to the vulnerabilities that their clients had, or did they have to do something differently because of the special situation of their clients. And I also asked them to mention during their contributions if some kind of advancement was brought about by the legal proceedings, because as you will hear, not every one of these cases ended with the clients winning the case, but of course, irrespective of that, changes might have emerged that eventually advanced the cause of such clients. And which I think was highly interesting was Adela's presentation, because Adela will not introduce us into a specific case, but into a new manual, so to say, that has been worked out for legal professionals. And the manual discusses ways by which lawyers can communicate effectively and efficiently with their clients. In other words, what we lawyers should do differently in order to understand and accept our clients as they are. I thought that I should introduce each contributor before they are making their short presentation. So first off, let me introduce Adrienn Gazsi, a lawyer, a colleague or an associate of the Kézenfogva Foundation. It's a legal aid foundation, and Adrienn is an absolutely indispensable expert in Hungary in the field of access to inclusive education and the legal infringement suffered by people with vulnerabilities. So Adrienn's presentation will be about a case concerning inclusive education today. A heartfelt welcome to all of you. So yes, I will discuss this matter in 10 minutes. And this is a case, a legal case concerning a young boy, a boy with special needs. And this boy in kindergarten did not get the care that he needed, in spite of the fact that an expert body concluded that he is entitled to special development of 3 hours each week and another type of special development in 2 hours each week. In spite of these expert conclusions, he did not get these kinds of development assistance treatments at kindergarten, and he was significantly delayed in his development, so he could only start his elementary school education with a 2-year delay. And an expert concluded that this delay was clearly due to the absence of this development treatment, and the mother turned to an equal opportunities authority, and the authority concluded that this was a case of discrimination and that the kindergarten was clearly to blame. And let me emphasize that the Equal Opportunities Authority has now developed a practice whereby whenever there is an absence of these development treatments, the authority concludes that this is a case of discrimination. So this is common practice nowadays. However, the mother was not satisfied with this and wanted to receive some kind of a compensation for this. And when this case happened, this is this was called a different name. Now it is called a grievance fee, and the mother called on the local municipality to pay this grievance fee to them. And this case was almost under the scope of the statute of limitations. So it was on the verge of that point when eventually the mother found me, and we launched the legal proceedings that were concluded in 2020, and if you like, with positive results, because the mother and the entire family was awarded 2 million Hungarian forints as a result of an agreement. But many regret that the agreement was reached because it cannot serve as a precedent as a result. Ever since then, a lot of people have been contacting our legal aid organization, arguing that they would like to have such a grievance compensation on account of the offensive treatment that their child had to undergo. So in light of this legal case, what I can tell them is only that if the grievance fees identify, the legal proceeding expenses will be aligned to that. And unfortunately, this is something that people cannot accept, because if they are losing the case, the legal proceeding expenses will be very high. So a compromise had to be arrived at, namely that the mother thought that the grievance fee should be much higher, not just 2 million Hungarian forints, but the mother simply did not dare to claim more, because we could not see in advance, we could not predict whether the case can be won or will be lost, in spite of the fact that what I saw was that the authority adopted the resolution on a case of discrimination. And in spite of that, we were requested to provide extensive evidence. We even had to prove that the child suffered from autism. So I must tell you that the burden and the overload of evidencing is very huge on the experts and on the families. But fortunately, we managed to arrive at an agreement, and this eventually closed the case. Since then, however, we have not initiated any similar legal proceedings, so I cannot tell you about any more cases that would substantiate some kind of a prediction as to what will happen if a child for several years is deprived of the development that he or she needs, and what kind of a compensation such a family will receive. So there are many sanctions in the Hungarian legal system for somebody not receiving the proper treatment. You can turn to the Equal Opportunities Authority, and the Infringement Act also provides for various cases to be qualified as an infringement, and the public administration proceedings can also be initiated. But a compensation is not the result of these proceedings. It's only if you launch a civil lawsuit where you have the chance of being compensated. Thank you very much. Could you please answer another question of mine? You mentioned that this case lasted for over 4 years. So by that time, the boy was well in school. So I have also experienced the same, that it is not a very efficient way of providing remedies, because the proceedings take too long time. But in this particular case, do you remember something that had to be done differently than in the rest of such cases? I understand that you had to involve an excessive number of experts here. Yes, indeed. On the one hand, we initiated these proceedings by emphasizing that it was an infringement of the right to education and emotional integrity, but even an infringement of the right to equal opportunities. And the evidencing is the other way around. So it is the respondent which had to prove that they have not committed considered a discrimination, but in the other two aspects, we were supposed to come with evidence. And the doctors, psychologists, and special needs teachers have been involved, and it was not just a single expert in the proceedings who passed on an opinion that the young person was a special needs person, and I had to prove things that were there in the expert opinions. So it was an expert opinion that the child was prevented from starting his elementary school studies at the required time. And autism specialists, special needs teachers, psychotherapists had to be involved. And the court, on the other hand, ordered the involvement of an expert who was not an expert in diagnosing children with special needs. And then we requested a supplementation to his or her opinion, and then we asked for the involvement of another expert, and we clearly felt the attitude of the court. To put it simply, they said enough is enough. So we realized that the experts were not the kinds of people, experts ordered by the court, who could dispatch opinions with a sufficient degree of detail. And I would like to emphasize that at this point, the child was already 14 or 15 years of age, and this young man felt that he was being vexed by all these tests that just kept repeating themselves. Yes, that was exactly my question. So do you think that the proceedings were traumatizing for the young person? But I think the answer is clearly yes, because the tests and the examinations kept reoccurring. But could you tell us a little bit more about that? And the last question I want to ask is that although an agreement was reached in the case, what was your gut feeling? Was the family happy with the outcome, or did they still have a feeling of deprivation? The family was motivated by the fact that it was not only the kindergarten that was to blame, but also the municipality. So the kindergarten was the respondent of the first rank, and the municipality was the respondent in the second rank. And the municipality claimed that they were not responsible in any way. But it was a huge success that we managed to keep them in the proceedings, and we also proved that they were to blame. So there were several points of control in terms of, maintaining, controlling quality, financing, etc., where they could have responded properly. So this was a success for the mother, because behind every such case, there is personal offense. And this mother in particular turned to the municipality repeatedly. So this whole case was preceded by this mother trying to make sure that her child will receive the required development. So in addition to the money that the family received, she felt that there was a certain kind of moral success. And my impression has been that they really wanted to win the case, but eventually they just accepted the agreement. And the reason why they did so was that they saw that this is going to be an evidencing procedure with no end in sight. And they were afraid that they would get an expert again, where they will start again by asking whether the child was a special needs child at all. So this was not a failure, but it was certainly a compromise. So I agreed with her that this was eventually a compromise, and a success would have been a win-win situation. Simona Florescu will join us online, and I will introduce her in English, and she will deliver her presentation in English.
So an attorney at law. Simona has been collaborating with Validity Foundation on strategic litigation since 2020, and she's also a great colleague of mine. Simona has brought cases to the European Court of Human Rights and worked closely with other European lawyers on national cases and strategies which aimed at advancing the rights of persons with disabilities. Simona Florescu has worked as a researcher in children's rights with Leiden Law School, and she was also a case lawyer at the Strasbourg court. Simona is going to give a presentation on a recent case they won at the European Court of Human Rights, and we will have a short video during her presentation with the client involved.
Good afternoon, everybody. Can you hear me well? Can you see me well?
Yes. Can you hear us, Simona?
Thank you very much for the invitation, and thank you, Adele, for your kind introduction. As you mentioned, I will be indeed speaking about a case that Validity has recently won at the European Court of Human Rights. And this is the case of Victor, or as the court has abbreviated it, VI versus the Republic of Moldova. And the judgment was released earlier this year in March, at the end of March. It concerned a 14-year-old boy whose mother had been murdered in front of him by the father when he was about 7 years old. He was then placed in the exclusive care of his aunt and the maternal family. During adolescence, the behavior of the boy changed. He became disobedient. He was entering into conflicts with other children, as well as with his aunt and with the family with whom he was staying. On occasions, he wanted to throw himself out of the window. In reality, the boy was suffering from post-traumatic stress and depression as a result of the loss of his mother. However, he never received any help, and his family was not aware that this behavior was a delayed reaction to the murder of his mother. They approached the local authorities, and at the recommendation of the mayor, he was placed under his guardianship. So the mayor became legally entitled to take all decisions in his regard. The boy and the family, it was communicated that this was in his best interest, and they were reassured that the authorities were doing the best for the boy. He was then placed in a boarding school where he equally misbehaved. The authorities sanctioned him for not showing gratefulness. His disobedience was diagnosed as a lack of empathy, which necessitated psychiatric treatment. He was also routinely committed to a psychiatric hospital and administered forced medication. The last placement, at the one which led to our case in Strasbourg, lasted for 4 months. It was between June 2014 and November 2014. And the reason for the placement was that he had a mild intellectual disability, and as I said earlier, that he misbehaved. This is what his medical record stated. The patient is impulsive, aggressive towards other children, doesn't follow the instructions of the medical staff, is negativist. During the 4 months of his placement in the psychiatric hospital, he was administered forced medication. As he did not accept that medication and constantly objected to the placement in the hospital, he was transferred to the adult section. Hospital authorities tried to contact the mayor, whom, as I mentioned earlier, was his guardian, on several occasions, but this mayor never replied to this request. The family was not aware of the whereabouts. They were told that the boy is fine and that he's happily going to school and living in a boarding school. At the same time, the boy was told that they did not wish to take him home and that they will never come for him. Upon learning of this situation, his cousin, who was living in Italy at the time, came back and assumed guardianship of the boy. During his stay in the hospital, Victor, who was 16 years old at the time, was administered no less than 10 different types of medications, including tranquilizers, medications to counteract tranquilizer overdose, and heart medication. After the release, and after learning what has happened to him, they sought justice. They filed criminal complaints concerning the placement in Moldova. But here, the prosecutor investigated all complaints because they considered that it was not proven that Victor has suffered serious consequences or serious bodily injury, which would result in a damage to his health. So all in all, everything that has happened to him was normalized by the Moldovan authority. Now, this is the background of the case, and I did want to stress the fact because there's a difference in how the case was presented in Moldova and how the case was argued in Strasbourg. In Moldova, it took 3 years to investigate the case and for the Moldovan authorities to dismiss it. Before I start answering your questions, Adele, if you don't mind, I would like to play a really short movie where you can see Victor and you can see in 2 minutes an excerpt of his own declaration and his own description of the facts and what has happened to him in the psychiatric hospital. If you don't mind, I would kindly ask you to play this movie at this point. Thank you very much.
Thank you, Simona, and please proceed with the video.
Când am ajuns în secție pentru maturi, acolo era ajuns un băiat de 18 ani, era agresiv, mă izbea în perete sau nu mă lăsa să stau și am vrut să mă apăr odată. L-a izbit, a căzut și s-a pălit. S-a dus la medicul lui, dintre care era un bărbat, și a spus că eu am pus mâna pe el, dintre care medicul mi-a venit, m-a prins așa de gât, mi-a pus mâna, mi-a strâns de gât și mi-a zis la perete, m-a pus și mi-a zis: îl mai atingi odată, vorbim altfel. Dintre care eu acolo am început chiar să am frică în mine. Deci, pentru mine, cu toți maturii și când am văzut că doctorul era, nu știu cum să spun, nu era nici doctorul de partea mea, deci am prins frică în momentul ăla. Încă am cu tremurul care l-am avut acolo, încă l-am și în ziua de azi, dar mă stăruie ca să uit.
Thank you, Simona. I'm sure that you had an insight on the domestic procedure. What do you think? Were the domestic authorities took into consideration the age of the client? What is your perspective on that?
My perspective is that the domestic authorities took into consideration the age of the child, but in a negative way, if I may say so, in a way that the age was a factor to be used against the child. So because of his age, he didn't have a right to be heard because it was not possible for him to be heard. At the same time, they took into consideration the age to say that the mayor was better placed to decide what is in his best interest. So actually the age was used as a factor against him in these proceedings, in my opinion, to basically incorporate a conception of best interest where whatever the authorities decide is better for the child, given that he is a minor. That is my opinion about what has happened domestically.
And what do you think? This is a great victory for Validity and all of you, but how did this case help to other children in a similar position? What do you think? Will it result in systemic changes in Moldova or in other parts of Europe?
I should say that this is the first case that the European Court has decided where the European Court has found expressly that there was a discrimination against this boy on the ground of age and disability. That's Article 14 of the European Convention of Human Rights, taken together with Article 3. So basically, the court has found that he was only committed to the psychiatric hospital because he was a boy and because he had a disability. It is the first case of the kind. So I do think that in that case, more cases should show this discriminatory angle. For those of you familiar with the European Court, you will perhaps know that sometimes the court really doesn't want to go into details on Article 14, on the discrimination angle, and usually the cases end with the most obvious violation, which in this case was actually the effective investigation. But the court did go further. And also one thing that the court has found and has applied is the so-called Article 46 of the Convention. Basically, they have said that this is a systemic problem in Moldova. They have said that this is not just about this boy, that this is happening on a wider scale in Moldova. And once they have this, Moldova will be monitored in an enhanced procedure by the Committee of Ministers. So because of these things, we are hoping that this case will have a wider impact and this will not remain confined to this particular situation.
Thank you, Simona, and again, congratulations to all of you on winning this landmark case. We are now proceeding to Adela Santos Lavigne. Adela is an attorney at law at Malaga, and she is specialized in disability rights. Adela is currently a project coordinator at an organization called INAIL, and also a member of the board of a Spanish organization which stands for Autistic Women Committee of Spain. Adela, in her current role, focuses on strategic litigation to advance the rights of persons with disabilities. And today, Adela will present a brand new guidebook she has been working on, which is targeting us, lawyers, legal professionals, but I'm sure it's useful for everyone, on how to communicate with our clients with disabilities. So this is a very practical toolkit, and I'm very fascinated by this. Please proceed.
Well, thank you for everyone to coming here. Sorry that I'm not able to speak in Hungarian for those who are native speakers here. I will try to do my best so the translations professionals that are doing such an amazing job today could translate in efficiently. So first of all, I would like to any of you to get you to know you, because I'm really proud of it, and I think it is a matter that involves today. I'm autistic, so I want you to think before starting this presentation, how many times in life have you committed any kind of mistake, any kind, and you have been punishing yourselves in your minds, saying, why does happen to me? Why I've done this? Why did I act this way? So this happens also to neurodiversity, and it happens in a way that it has created barriers with professionals. I haven't heard to anyone of my community or any other neurodiversity to say, I trust my doctor or I trust my lawyer. Usually I'm thinking about going to a doctor. I'm thinking about going to a lawyer. And this gap happens in a way that even scientists were quietly interested in why communication between individuals, when it happens to neurodiversity, mixes. So this is Dr. Coleman and Damien Milton, did this interesting telephone system where he put several kids, autistic kids. He put neurotypical kids, no one with disability, and realized that when they are not mixed, communication fluid. But when they mix and put autistic kid, after all, a normal kid with non-disability, then the last conversation what we was supposed to end the row didn't come the same way. So that means that communication happens differently. And it's naturally involved in neurodiversity, so it's natural in humans. So this double empathy problem that Damien Milton discovered in that scientific interpretation, it means that we misinterpreted naturally each other. So now, here, what we're going to discuss today is, why as lawyers, do we have to go further and understand and try to change our way of communicating our clients with disabilities? Not only because it has trust and collaboration, it also empowers people with disabilities to trust you and think about strategic litigation as a way to try to do their best for their rights. So with this presentation, what I try to do is to effectively give you some tips so you are able to improve your skills. So imagine you want to start with the first client. Some of you maybe are studying law today and are here to hear us. Some of you maybe have previous experience but are struggling with the idea of being alone with a person with disability. So this would be the first thing. Start naturally. Ask, what do you need? A needs assessment. It means identify sensory things that maybe could handle them, that maybe could make collapse. There could be any kind of smell, noise, so you can try to adapt your space. Obviously, you cannot change your office, but you can pick which places of your office maybe it's more comfortable. And that's the first place to sit down and start talking about a thing that if you're still thinking about that problem that pitches you, it's inside of that person and wants to transmit you. Secondly, prepare inaccessible materials, and then you will say, you know how to prepare them, but I don't know, I have no idea. Well, we have today see that how intelligent artificial programs could help on that. We have so many tools, and if not, it is our time to train us. We have to prepare themselves. If now anybody, thanks God, with a disability have a legal capacity, the opportunity to go to court, it is our duty to make sure they only not understand their rights, that they know how to use them, and they understand the risk of the case they're going into court. So that means try to do this easy to read documents, PDFs accessible so people with low vision impairments or any other kind of disability can, in which their own screen readers read, and try to don't use jargon when it's not necessary. Let's think about the second step. We are going to structure our meeting. You are waiting for your client. Nerves are around the atmosphere. So what can I do? The first thing will be, is your office physical accessibility enough? Is that person a wheelchair user? Do you need something else? Because usually disability is not a thing about only one diagnosis, just to let you know. Most people with disabilities will have more than one disability, and you will have to adapt to that context. So you will have to adapt also your communication, and that means not only to try to avoid jargon, also to avoid any kind of figurative speech. We won't get you if you start using those colloquial ways of expressing yourselves. Not only because they are legal, just because in our daily lives we don't get it. And also, try to think about making accessible a quiet room. It doesn't matter if this is a restroom, it's not the nicest thing, but a place that maybe if there's need of so many breaks, you can take some time. Obviously, always taking comprehension step by step. If you're structuring the meeting, you will have to have that agenda, try to adapt it and share with the person who is in front of you so it knows more or less if you're at the beginning, the middle, or the end of the meeting. Adjustments for sensory needs and cognitive needs. We're talking about this, but there's people here that I've seen with noise cancelling headphones, but there's many others that need some fidget toys to manage their stress. Also, they need breaks. They could also need some extra time to process what you're talking about. So maybe your meeting is not going to be a one-day meeting. Maybe you will need extra time, and it's something that you have to prevent and think about it. Reassure always that the client is also connected with what you are saying. So how do I ensure that my client is taking what I'm trying to explain to them? First of all, you have to simplify legal concepts. That means not only trying to use an easy-to-read version or a plain language version, also to try to make it examples in daily life basis that can try to connect what the right or the law says to something that is connected to the real life. Because obviously, between lawyers, we talk in jargon, and it's a colloquial way to us to express and talk about the right. But if most of people with disabilities haven't had even the right to know their own rights, it is our duty to try to express and explain to them what are they fighting for. Not only about winning a case, it is about what impact it's going to have on you. Obviously, conflict understanding, it's, as I've said before, is necessary. So offer the information as format as it is needed in this need assessment that the person is going to provide you. Imagine now that you have this meeting, your client, as a person with disability, think that you can do a good job, and you want to find a contract that says, now you're my client. Explain consent clearly, because usually people with disability in so many countries haven't had the opportunity to even consent their own education, their own basic life rights. So it's going to be the first time that someone maybe is talking to them in a jargon saying, do you want this? So try to explain in a really simple way what are the risks, what is going to be the benefits to go through it, not only in terms of law, also in terms of social opportunities, see the person as a global, and also respect communication styles, even if it means you will have to have more time to that meeting. So after the meeting, what I usually do? First of all, in that meeting, we have rechecked what accessible formats we are going to use to communicate ourselves. And once in a while, not only because the client maybe reaches out, I'm the one who reached them out and say, we are in this stage of the procedure, how are you doing now? The next step is going to be this one. So transparency in our way of working must be encouraged. And I think most of us, as lawyers, really trust of our own ways of working. And obviously provide continued support, because in some of those cases, you will realize that the impact in the social and daily life basis of that person can be huge. Maybe they're suing to his own company that are because they're workers. Maybe they're suing to someone. In that case that she was saying, it may be the main hall, and they're starting maybe to put some barriers for them to access to any other services. So it's going to be challenging to go through the process. So now you're going to court, and it's your turn to try to fight for adjustments in there. So what I will say is, here we have what theoretically would be ideal, to think about the physical and sensory adjustments. It means also about noise. It means also about this atmosphere, and also about the mobility aids. The communication adjustments, not only maybe sign language interpreters, but also intermediaries or facilitators, depending on the country, and those extra times are regular breaks. You will see that not so many times that happens. This is a first example of a case that we had. As my company colleague said, I work, with a non-profit, I collaborate. I'm a board member of CEPAMA, and we usually provide legal advice, like with non-cost, just to make them sure that they are doing what they want. So at some point, my job in there is to intermediate with their lawyers and explain to them all those previous steps and why their own clients need us. In this case, she called us and said, well, I don't understand what is happening. I've suffered from moving at my job, and I don't know exactly how to reach out to the lawyer because I started with this one, but I cannot afford it anymore. So we helped her, first of all, to go to a state lawyer. After all, we also help her to try to communicate better with his lawyer, because when she tried every single time to reach out and ask for information, because due to her disability, they almost not explain anything to her. And what do they explain is that we are fighting for your right, and we are like, okay, but try to explain to her what will be her role, what is expected for her to do. There is any news related to her case. So it took several months, but we successfully, in going through court, helped her to get understood with her lawyer. In another case, it's actually a case that we are having at my office. This is John. In this case, we are pro bono. We are as state lawyers, and he was at his house, he went through special education in Spain. Now already he's not working, but he spent so many hours playing to League of Legends. I don't know, so many people here will know that game. But he goes to, this place near and buys so many cards because he likes to have so many suitable things. He likes to have more objects, more things, but he didn't read that there is so many, not only interests. It means that whenever he reaches out, he provided his ID and also like a card that was connected to a bank account that usually his mother gave to him to go to small shoppings. Now, the company has sued him, asking for interest and the whole money because he didn't pay anything. The bank account was with no money. So we have asked for an intermediary to ensure that he could participate in the process. And the response of the Spanish court will be, the law says he has the right to an intermediary, but there is no service provided in Malaga. So now we will have to fight, then to suspend, or to fight that his procedure is not going to be obviously legal in the terms of the Syri Party and the access to justice for him. So, as a conclusion, I will say barriers in communication are everywhere, and people with disabilities are everywhere. And as you will see, our role as lawyers must be not only to give them the opportunity to understand our role, also their role, understand their own rights and objectives when they are going to sue, and be sure they're able to participate in the process in an active or a passive way, in terms that when they finalize the whole process, even though maybe they don't win it, they could understand what they were fighting for. So, in any way, inclusive legal communication, I do think, builds trust and empower clients to go further. And by adapting our practices, I do think we can create a more justice and accessible legal system. Thank you for all for listening.
Thank you, Adela. We will proceed to Márk and have hopefully a little time for questions after the last presentation. És végül, de nem utolsó sorban.
But last but not least, let me introduce Márk Pető, who is specialized in civil law, but he is also committed to human rights, and he represents marginalized groups like the Roma and people with disabilities. He represents NGOs, and he also has cases related to press freedom. We invited him to present a case that is a major headache also for me, because a wrong precedent was created. But the positive message of this case was that it resulted in an award-winning documentary. A documentary was made on the case. I think it has major benefits, exceeding the limitations of a legal procedure, and it has a major impact on raising social awareness of this problem. We have a very short trailer, just 1.5 minutes, just to whet your appetite and encourage you to watch the documentary. And then I invite Márk to say a few words about his direct experience with the case. And now we will play the trailer of the documentary first. Thank you. And Márk, please just briefly explain where this lawsuit was initiated, what is its current status, and then we may have some questions to you at the end. Thank you for the introduction. Welcome, everybody. Good afternoon. This lawsuit was started in 2017. It has been concluded by now, but, well, in a way, it is still underway. I had 12 plaintiffs, parents and children. There were 6 adults with severe disabilities. They are aged between 30 and 40, but in terms of the status, they can be considered a child. They are not able to support themselves, and they require continuous care. Their caregivers are their mothers, who the other 6 women in the lawsuit are between 65 and 85, and the defendants were the authorities, child protection authorities, and the Ministry of Human Resources, and also the Ministry of Interior as legal successor. I was contacted by the mothers because they did not receive any government support for home care. They joined forces to find a group home for their children. The possibilities they were offered were just close mass institutions close to the border, hundreds of kilometers away from Budapest. They visited them, and they were hospitalized people. They were very bad conditions there, sedated in those institutions, and they didn't want to send their children, disabled children, to these institutions. They thought that they would condemn their children to death if they were sent there, and their waiting lists were very long. They had to wait for long years until their children would be admitted to those institutions. They did not want to use this opportunity, and they continued. They stayed at home for decades to care for their children, and they had to give up their life, their private life. Their life opportunities were highly limited. Their families fell apart. They were left by their family, friends. They became lonely, and they were worn both physically and mentally. And even the healthy children in the families were severely traumatized. The mothers could not find a job. They haven't been on a holiday for decades, and their life is overshadowed by the fear of what is going to happen to their children when they are no longer able to care for them. And the consequences for the children were also brutal. They were left behind. They didn't get the required development. Their condition was deteriorating. They did not have the possibility of an independent life. They had to live together with their elderly parents, and they were exposed to the abilities of their parents to care for them. The Hungarian government is obliged by law to provide care, supported care for these people with disabilities. The Social Care Act was adopted that provided a possibility to provide care homes for people with disabilities. They provide accommodation and daily services to support their daily life. Since 2015, new places can be provided only with the supported accommodation close to their current place of residence. In the case of my clients, this accommodation, this institution should be provided in Budapest. And, well, in the case, in the lawsuit, nothing has happened from them. There is no supported accommodation available in the region, not even mass institution. And the mass institutions offered to my clients are simply unfeasible due to the long distance. The government has an obligation to demolish these mass institutions by 2036. And those people with disabilities who live at home are not offered places. We initiated human rights, individual rights lawsuit that their right to privacy was violated, and they claimed a compensation of 5 million forints per person. And we also claimed that the government or the defendants provide supported living accommodation for my clients, and the lawsuit was concluded in 2022. It was a very complicated procedure. We listened to the testimonies of the mothers and witnesses who talked about the difficult life situation of our plaintiffs, and with years going by, frustration and disappointment was increasing, as well as the burden on the families was also increasing. Tragedies happened one after the other. One of the plaintiffs died, one of the children died, and one healthy child of a mother attempted suicide, and he himself had to use a wheelchair for a while, and then the COVID came that increased the isolation of families, the exposure of these families to an unbearable level. The Ministry of Human Resources was replaced by the Ministry of Interior, and the legal succession took place in the lawsuit, which made the case even more complicated. We had to file a complaint against a judge. So one of the judges was replaced at the first instance, and the lawsuit was accompanied by the cynicism of the defendants, and they blamed the mothers for the situation. First, at the first instance, we lost the lawsuit, and then we filed an appeal. We had a court of second instance that returned the case to the first instance, and the ruling was a victory because they identified the violation of rights and ordered a second procedure. For technical reasons, then we won the lawsuit both at the first and the second instance. We had 6 claims, and we had 12 plaintiffs. So there's 12 times 6 claims were won, but the defendants also filed an appeal. So after 3 victories, we reached the level of the Curia, the Supreme Court, where the claims were rejected. And it was confirmed that my clients have the right to supported accommodation, and it also affirmed that it is not available in Budapest, and it confirmed that it has very dire consequences on my clients. But he said that there is no legal civil law relationship, but it is a public law relationship between the clients that the court does not have the right to condemn the state. In this case, I think it was the wrong decision, and the Curia just didn't accept that there was a law that imposed an obligation on the government and public institutions. And I think that the principle of splitting the branches of power was severely violated by this court ruling by the Curia. Then we filed a petition with the Constitutional Court, where we also lost the case, and currently we have filed a petition filed an appeal with the CRPD committee and the European Court of Human Rights. And well, it will take a long time, but we are looking forward to a more positive outcome. Well, all in all, in conclusion, well, we lost the case, we lost the lawsuit, which is a major disappointment for me and for my plaintiffs, for my clients, and it created a wrong precedent that is used by public authorities since then. And Adele asked me to leave you with a positive message. After this, it is very difficult to leave you with a positive message, but well, at least we highlighted the importance, we drew attention to the importance of this problem. This documentary was produced and it received awards, it was granted awards, and it is available on television channel RTL, and it also created wide publicity. And the mothers who've been fighting for their rights for 30 and 40 years, they still did not give up. They started to raise funds and decided that if they are not supported by the state, they will take these responsibilities and will try to finance the construction of a supported accommodation for their children. Yes. Well, I thought that for a conclusion, because I knew that it will not be a happy ending, so I want to ask the colleagues to say a few sentences, to say some closing remarks. So please, Adela and Simona, just please tell us, why is it worth continue fighting? So
of these traumatic outcomes and sometimes very struggling with the courts, what is the benefit of doing this work? Először akkor talán Adrienn menjünk sorba, hogy mit gondolsz, hogy miért érdemes ezt a munkát mégis csinálni?
So Adrienn, why do you think that it is worth continue fighting and doing your job? I think it is worth doing my job because I have many cases and I can identify the legal inconsequences, the legal issues, the problems that are in the system that would otherwise be unnoticed, because this is a very special field, social law and the related decrees. So it is very difficult to identify these problems, very difficult to report these problems to the Commissioner of Fundamental Rights or to the Ministry of the Interior. We report these problems to them. This is not a major success, but I still consider it a success when I see that legal regulation is amended as a result of a report filed by us, and we can help a lot of people. So our activities can lead to structural changes, which is a major achievement. Yes, I believe that. And and this lawsuit had the impact on me that the parents became aware that this is a government, this is a state obligation, and we raised awareness. Even if you have a lost case, if it has an awareness-raising impact, it can be a positive thing. It can highlight the importance of the field. It can highlight some system-level deficiencies or shortcomings that can be remedied. So as far as case management is concerned, or in the educational system, it is very important to raise legal awareness in the education system without generating conflicts. people just don't take lawsuits, don't initiate the lawsuits because they take too long by the time they are finished. Their child finishes school or graduates from school. I also provide advice to clients, and I try to raise awareness. I offer my services to clients and assist them. Adela, what is your comment?
I would say that as a lawyer, when I think most of us are here, when you study your career, you embrace justice. That not means the justice system. So that means that as an activist, it is a matter of human rights. So you cannot get tired of human rights. You cannot disprevent of it. You cannot say it is involved in your lives. So you have to take it as a playing chess, which each case could mean changing policies. So you have to thinking about each case an opportunity to put the debate in discussion and also to make changes, not only maybe for your client, even for more. So when I try to embrace a case, I always tell them, this is sometimes it's not only a matter of you, it's because there is so many like you. So if you have the energy, if you have the privilege to get to know what are the risks as a person with disability to put you in this situation, not only in legal terms, I mean psychologically, I mean financially, whatever, then go for it, because we're gonna fight it as forever. But just what I try to do is always put the balance. You know, there is no one here, I think, that have embraced a case that could say there is no physical, emotional, or social cost on it. So I think this is our responsibility too when we talk about consent, going to sue. But obviously, as an activist and idealistic, I always tell them, if I detect a legal violation, and you have this opportunity, go for it, because our responsibility are not only as person with disabilities or as a lawyers is also as a community and societies to highlight what is not working at all. And we cannot wait for parliamentarians or policy to move further because they are not doing it, because we are a minority. And in my case, it would be minority of minority because I'm a woman. So in that case, what I would say, just put your balance, and if you do it, then we will manage. That's what I would say.
Thank you for these encouraging words. I don't know if we still have Simona, so she can comment on it.
Yes, I'm here. I see myself.
Yes.
I think I would like to mention on my side that from the perspective of the client, I have seen empowerment of clients through litigation. I have seen how litigation changes them and how they find their voices. In litigation that Validity has conducted, we have successfully, we were able to change the residence of persons with disabilities from institutions. And that's how they found their voices. They knew their rights. So I think that is a motivating aspect of the job. From the perspective of strategic litigation, I also would like to say that litigation sometimes is unsuccessful and many times is unsuccessful, but in other occasions, it does lead to systemic changes. For example, the laws on guardianship have changed in countries like Moldova, thanks to litigation at the Constitutional Court. They have changed in Romania, thanks to litigation in Strasbourg and at the Constitutional Court.
Thank you, Simona. Sorry for interrupting you, but I've been just notified that our time has really run out. So I think we all agree, and mindannyian egyetérthetünk abban, hogy
I think we can all agree that it makes sense to continue our job, even if we fail sometimes and we face challenges, but well, we can also achieve very important structural changes with this strategic litigation. And I was asked by the organizers to conclude the discussion. I think we don't even have time for questions, But, well, I don't want to prevent you from asking your questions. But if you have any question, please ask. I think we still have time for one question, for a single question. But if there is no question, then I will conclude today's event. And, well, I think Christina wants to, Orshoya wants to say a few words to conclude the event.